2 o'clock for the reconvening hearing from December 12th, 2022. City of Freeport Electoral Board hearing dated today's date of December 19th, 2022 at City Hall at 314 West Stevenson Street. We were reconvening for the hearing case of Sheldon versus Ross, case number 2022 EB02. Next on the agenda is identification of board members. I'm Jody Miller, Mayor of the City of Freeport, as well as the Chairman for the Electoral Board.
Don Parker, Alderman.
Debbie Anderson, City Clerk.
So we'll call the case of Joe Sheldon versus Arthur Ross, case number 2022 EB02. Conduct the hearing.
And for the record, my name is Aaron Zito. I'm the attorney for the Electoral Board. I just wanted to provide a brief roadmap of how the hearing is going to proceed. So understand I'm going to ask for the parties to identify themselves, and then we'll swear in anybody that we need to have sworn in. The objector is going to be given an opportunity to provide an opening statement. The candidate is going to be given an opportunity to provide an opening statement. The objector will then be able to provide their case in chief, present any witnesses or evidence that they may have in support of their position. The candidate then is going to be given an opportunity to cross-examine the objector or their witnesses. At that point, then the candidate will be allowed to present their case in chief, present any witnesses or evidence that the candidate may have. The objector will be given an opportunity to cross-examine there. Then I will ask for closing remarks from the objector as well as then from the candidate. At that point, we'll close the evidentiary portion of the hearing, and the Electoral Board will then be given an opportunity to deliberate and then render a decision on the objection, and then we will, at the close of the hearing, we'll ask to recess this hearing also then to a date to allow me to prepare written findings and decision that will then be approved by the board in open session. Any questions?
No.
Mr. Ross, any questions?
No, none to say.
Okay, so I'll ask the objector to identify themselves.
Attorney Kylie Miller on behalf of the objector.
Art Ross, third ward alderman, also candidate for the third ward.
Okay. Attorney Miller, will your client be providing any testimony? No. Okay. So then, at this point, we'll just probably at this time just swear in.
So if you raise your right hand and repeat it to me, do you sort of tell the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
We'll swear in additional witnesses.
Okay.
Okay. There. So, Attorney Miller, if he has an opening statement.
Yes, good afternoon, panel. Mr. Ross submitted a packet to be placed on the April elections. As part of that packet, he submitted 33 signatures. We are objecting to 10 of them as being legally deficient. At the end of these proceedings, we will ask that all 10 be stricken, and a finding that because he is under the statutory minimum signatures at 23 should not be placed on the April ballot.
Mr. Ross, do you have
Yes,
a statement?
I believe I submitted 34 signatures, and the signature that I do have are valid signatures, and I have the proof of proof.
Okay.
Can we verify if it's 33 or 34?
We'll get into that
Okay.
as the case proceeds.
Okay.
All right, so next then will be the objector's case in chief.
So let me just start early. So this is just our packet of different exhibits that we'll be going through. So like I said, we made 10 objections to the different signatures, starting with page 1, line 1. The individual signed for both the People's Party and the Democratic Party, and that'll be in that packet there. As the panel is likely aware, party affiliation is a primary component of signing for petitions. What you're swearing to when you sign a petition is that you are a qualified primary voter for the party listed on that petition. Specifically, the language in 10 ILS 5/7-10E gives the requirement for aldermen using the language of his or her party of the ward. The union signer must be a member of that party. Unfortunately, by signing for two different parties, even if they're different positions, the individual has declared that she is a member of both parties, rendering her signature invalid on both petition pages. So Mr. Ross's and Ms. Sellers' signatures for this particular individual are invalid. Now, Ms. Sellers was not objected to, so that is not before us, but the signature is invalid for that purpose. The timing of the signing does not matter because, again, having signed for both, she has declared that she is a member of one party and then another party. The purpose behind party affiliation is to prevent a party from interfering with the nominating process of an individual party. And any kind of effort to switch parties has to be clear and deliberate. You can switch parties, but it has to be just one party. So if she intended to be a signer for the People's Party, she could sign for the People's Party for any position, but cannot sign for the Democratic Party in addition. It's one or the other. And by signing for both, she has rendered her signature invalid. Turning next to, I'll just lump them all together because it's pretty much the same legal argument for all of them. For the next 8, the individual who had signed in these particular lines, so just point them out, page 1, line 2, page 1, line 3, page 1, line 4, page 1, line 9, page 1, line 10, page 2, line 6, page 2, line 10, page 3, line 1, are all outside of the 3rd ward. And I do have copies of the map for the wards, and they're kind of hard to see. If you have trouble, let me know. I've got my computer, we can zoom in on them. But the 1, 2, 3, and 4 are all marked out, and they are, specifics. Actually, it might have ended up in that file. But because some of them are in the same household, it's just 1, 2, 3, and 4 to mark out where these individuals are residing. The statute, again, to quote, says that if a candidate seeks to run in that as alderman in a municipality, that person needs to obtain signatures from within that ward. The language is very specific that it has to be the party of that ward. Now, in the statute, there's another line that does qualify for remap years, but all that has to do is how the numbers are calculated. It does not apply in this particular case because the very last line says that in no event shall the signatures be less than 25. So how we calculate the numbers doesn't matter because the minimum is 25. The statute is very, very clear that the minimum is 25 and then signatures must come from within that ward. Just because they are slightly outside of the ward doesn't matter. They must be within that ward. And to quote a couple of parallel cases for you, quote, the voting district for the resident judgeship associated with the 3rd subcircuit is obviously the 3rd subcircuit itself. No other voters may participate in electing the resident circuit judge associated with the subcircuit, end quote. And that's going to be, and I have that list right there, Aaron, Clips v. McHenry County Electoral Board, 20 IL App 200127, unpublished, paragraph 38. And then another one, quote, the one cannot be a qualified primary voter for the office of Illinois Senator for the 18th Legislative District unless one resides in that district, end quote. And that's going to be Neal v. Cook County Officers Electoral Board, 2018 IL App 1st, 180421. From a factual standpoint, the candidate in this case is a current member of the City Council. Just because he might not have been present at particular meetings where these maps were approved means nothing. He had actual notice that this was going to happen. Because it was a census year, because the census data indicated wards needed to change in Freeport due to population changes, he was on actual notice as a member of the board that this was going to happen and should have reviewed the maps. Second, a simple review of the map itself, as you have in front of you, would have told him that these streets were no longer in his district. Just because the clerk's office might not have had it formally updated did not mean that this was the map that was going to be used, as was approved by the City Council. Mr. Ross's Participating in that meeting, again, does not matter because as an active member of the council, he was on actual notice. Mr. Ross cannot now plead any kind of ignorance regarding the remap to his location due to his failure for any kind of due diligence. He should not now be rewarded with a finding of substantial compliance or reasonable oversight or detrimental reliance simply because he failed to perform his due diligence. The Supreme Court actually does have a case that is very similar. Most recently in 2021, Corbin v. Schroeder, and that's going to be 2021 IL 127052. In Corbin, two candidates had asked their clerk's office for particulars on their election, and the clerk had misinformed them, not intentionally, but it told them they only needed 24 signatures in order to be placed on the ballot, instead of the actual requisite 700. The clerk believed that due to COVID, the numbers had changed, and the clerk was mistaken, and the board at that proceeding did find detrimental reliance on behalf of the candidates and let them be on the ballot. But it went all the way up to the Supreme Court, and even during COVID, even with all of those circumstances, the court held that that was legally insufficient. When the statute is as clear as it is in this case, and the ones that they quoted are almost identical, they had to deal with non-partisan, but same language. But implicit in the law's provision that nominations be made through nomination papers containing not less than the required minimum, the nomination papers may not be made through anything less than the minimum required by law. Substantial compliance, which is typically something that's dealt with here in election law, substantial compliance does not apply because it is not a valid justification for deviating from the clear and unambiguous minimum signature threshold held by the legislature. And their final finding was that the residency requirement that signers reside within the ward is clear and unambiguous. Signatories to nomination papers must reside within the ward for that candidate who is seeking election in order to be valid. The purpose of gathering signatures from within your ward is to demonstrate a minimum amount of interest by the individuals who are going to be electing. You have to demonstrate that you have enough support within your ward in order to be placed on the ballot. And that's why it has to be within the ward itself. 1 street over, 2 streets over, does not matter. It has to be internal and inside the ward. And therefore, substantial compliance is not going to be sufficient in this particular case. The legislature is extremely clear on this point. And then finally, we didn't get into this on the last one, but the last signature, which is page 3, line 6, the signer is a canceled voter. Just to clarify, there's a lengthy process to be made a canceled voter, but once you're a canceled voter, you have to completely re-register. You are no longer considered registered to vote. When you're inactive, which is in the middle of this process, you are still considered registered to vote, but after the process is complete and you're canceled, you're no longer registered. Can they re-register? Absolutely. But at the time of their signing, they were not registered to vote, and therefore that signature is not valid. And if you have any questions on the cancellation, I'm happy to answer that as well. So you have all of our exhibits, and if anybody has any questions on any of the previous information, I'm happy to answer any questions.
This time I'll ask the board if they have any questions for the objector.
I have no questions.
I don't know if there's a lot of information in a very short time.
Yeah.
That's,
Yeah.
yep.
Yeah, are we cross-referenced, are we double-checking these outliers?
I do have one question for you.
Mhm.
You
Almost as
referenced,
this one.
you referenced that the timing of the petition, signing of the petitions does not matter. Is that the Patton case that you're referencing?
So it's the 2018 one. I think I gave you my full list.
Yeah, Patton versus Illinois State Board of
Yeah.
Elections 2018 for that first.
Yeah, and so that one's actually really famous. That one, so in the particular case I'm referencing, an individual in Southern Illinois had signed his best friend's petition, super reasonable, right? And then tried to run as a candidate for the opposite party and was barred because he was no longer a qualified elector in his own party because he had declared when he had signed for the other party, even though it was his best friend, that he was a member of that party.
Are you familiar with the Watkins case?
I believe so. Right.
Yeah. I just want to make sure
Yep.
that we're dealing with the same set of law. My understanding is that that case stands for the proposition that you do then look at timing of when, who should sign first.
Sure. Yes, I did see this one, but since it's from 1984, there's been changes to the statute and case law is clarified since then.
I'm sure this is, I don't see this as being a case that's overturned.
No, I don't think it was.
There, so just two different districts.
I believe so.
Okay.
Either of them in our district?
No. Just, oh, well, this is first district, first division. This is also then the attorney in the Penn case, that would be the first district as well.
Yes, first district.
First district.
So we're just missing.
No, if no one has any questions at this time for the objector.
Attorney, do you agree that those outliers match the addresses? I have not done a check.
I suppose that this is the evidence that's being presented by the objector. It would be on Mr. Rawson to present evidence if he feels otherwise.
That that's not correct.
Correct.
Okay.
So, Ms. Ross, do you have any objection to any of the documents that were presented by the objector, these documents?
No, these are the same, documents that I have, stating that, these residents live within the third ward. And those are the residents that, I received my signatures from.
Okay, I just want to know, do you object to the validity?
No, no,
of
to the
documents, if they're
paperwork, no.
false or anything like that? No?
No, because these are the same thing I have, no.
I just look for concurrence and from the board to accept these exhibits.
To accept it, the documents.
In evidence as objectors exhibits A.
Is there a motion to accept these into evidence?
Yeah.
Is that a yes? Second,
yeah,
I'll
make
second
that.
that.
Okay. All those in favor?
Aye.
These registration forms don't show what ward you're in, though.
No, and they're directly from the clerk's office, and I have emails confirming that they're from her. But no, it just shows their address, and then compared to the map.
Bam. That looks a bigger map for me.
I have my computer, I can open it up, and you guys can zoom if you want. As an option.
I would.
That's fine. If that's, you're free to ask for it.
Yeah, it's hard to get them all on one page, you know?
Yeah.
So this has all changed since we've redone the, since the census and we redid the mapping. That didn't change, okay.
My understanding.
And this is a current map?
That's my understanding.
Yep.
Attorney, that that's the current map from the.
I didn't realize that 4 still went across it.
No, I didn't either.
That's why I was wondering if this is accurate.
Ford, Louis, Towers, sorry, Douglas, and
Hold straight from the county list. And feel free to do whatever you need.
So, is it really necessary that we do each one of those, or do we wait until Alderman Ross has?
I think right now is your opportunity, if you have any questions about
Okay.
whether or not
Okay,
they are or not.
okay.
You know, about any of the evidence that's presented there, so. Certainly, we can wait till deliberation as well to go
Okay.
through this as well, so.
I think we might as well wait until we deliberate,
Yeah,
instead of
I'm
checking
ready.
every single one of them.
Thank you.
Mm-hmm.
Did you have anything additional?
No.
Mr. Ross, did you have any questions for the objector?
No, not at this time.
Okay. So then at this time, then we will move into, Mr. Ross, your opportunity to present